Thank you very much, Professor Forsyth, for that very friendly introduction. It's a great privilege to be here and also a rather daunting one, as I see the honorand sitting right in front of me, and I should get to my text. Exactly 98 years ago today, 15 young New Zealanders played a game of rugby against 15 members of colleges of what I understand is known here as the other place. One wit said that the game was an even one because 6 tries were scored in the first half and 7 in the second. I need not tell you that all the tries were scored by one side, or which side that was. What I should tell you is what those young New Zealanders knew and thought, and I draw on the words of a marvellous New Zealand novelist, Lloyd Jones, writing in the Book of Fame. This is what he said: "Space was their medium. We championed the long view, the vista. The English," and that's a word that will come up often in the early part of what I have to say, "the English settled for the courtyard. The English saw a thing. We saw the space in between. The English saw an obstacle. We saw an opportunity. There were the trails of a life spent in a valley and the distance travelled between obscurity and fame." I begin with that game and that journey towards fame, which our honorand tonight would remind me later included fatigue and the irresistible attraction of defeat for a number of reasons. The first just mentioned is personal to Sir David and me, and it goes back to our first meeting at Emmanuel on the 1st of May 1970. The second reason is to make 2 points about the law applied in that situation. The laws of rugby, because that's what they're called, the laws of rugby are privately made these days by the International Rugby Board, and they are international. They are not made under official authority. They are administered by privately appointed referees, people much more important these days than judges, not judges appointed by the Queen with protected tenure. The third reason to go back to that group of young men is to suggest the central and critical significance of differences in ways of thinking. The thought is what counts. Einstein and Matisse were also causing a stir in 1905, and an artist speaking to a reporter from Le Figaro discussed the way the New Zealanders conquer space. How then should we think of sovereignty in 2003? How do ideas of space, courtyards and vistas, obstacles and opportunities help us in thinking about sovereignty? As the handout indicates, I shall address sovereignty within national constitutions, notably those of the United Kingdom and New Zealand, and particularly parliamentary sovereignty, and sovereignty in international law, and the impact of that body of law on national law and the consequences of that impact for parliamentary sovereignty. The areas are vast. I realise that I am risking being superficial, but given the professional interests that Sir David and I share, I do want, like those young men, to champion the long view, the vista. The doctrine of parliamentary sovereignty, to begin with that, it has been famously said, is almost entirely the work of Oxford men. On that matter, I mention mainly developments in the 3 decades since that Houston essay. This is familiar material, and there is an element of presumption in an outsider adding to the extensive commentary, but perhaps distance brings some perspective. I mention 6 matters, the last of which takes me into the role of sovereignty in international law. And I begin with a statement of the orthodox position. It's hard to go beyond Albert Venn Dicey speaking only 120 years ago. The principle of parliamentary sovereignty, he said, means neither more nor less than this: namely that Parliament has, under the English, that word again, the English Constitution, the right to make or unmake any law whatever, and further, that no person or body is recognised by the law as having a right to override or set aside the legislation of Parliament. Dicey was, of course, much vexed later on over the impact of this proposition on his views of the Irish question, facts testing theory. The first of my 6 matters is the Scottish element of the British Constitution, and I'm concerned with the argument that has long been made to the North that the Act of Union restrained the powers of Parliament. 50 years ago, in the McCormick case, the Lord President, Lord Cooper, agreed with the Lord Advocate's concession that Parliament could not repeal or alter such of the provisions of that Act as were stated to be fundamental and unalterable for all time coming. So there was a dent in the orthodox doctrine. The remarks in that judgment, said Professor Houston, of which it might be said that had they not been made by Lord Cooper, they would not have been believed, may, he said, be disregarded as completely contrary to the whole tenor of English authorities on the point. But I wonder, why should not a fundamental document such as the Act of Union be seen as having some restraining effect? Such a question has been asked in New Zealand about the Treaty of Waitangi of 1840, signed on behalf of Queen Victoria and by Maori chiefs, by means of which New Zealand came under British sovereignty or governorship, depending on whether you read the English or the Maori text. But I should not go down that route tonight, particularly since the New Zealand Parliament in the legislation that Christopher mentioned earlier, just 3 weeks ago, when enacting the Supreme Court Act, replacing the Privy Council with a new local court of final appeal, included a savings provision stating that nothing in the Act affects New Zealand's continuing commitment to the rule of law and the sovereignty of Parliament. It's interesting to see that re-emergence of 2 of the parts, the titles to 2 of the parts of Dicey's book, with its inbuilt tension. And if not to set against, at least to relate that proposition to the statement that Parliament had made not very long earlier in 1986 in the Constitution Act, that Parliament continues to have full powers to make law for New Zealand, not sovereign powers. Rather, I move on from the internal question raised by the Scottish and New Zealand situations to a second matter, discussed with great distinction in the first of these lectures by Sandra Day O'Connor, the impact of European law and institutions on the British Constitution. Because so much has been said on this topic since at least the 1960s, I wish to make only 3 references: to the judgment of Lord Bridge in the second Factortame case in 1990, to a debate in the House of Lords on the 5th of June 1996, and to Sir William Wade's article, I was talking to him about it just before, in the October, and it's a great joy to see you here, sir, in the October 1996 Law Quarterly Review. With related commentaries, they all demonstrate the value of different ways of thinking by people in different positions within public life. Lord Bridge, it has always seemed to me, was declaring, with the understatement befitting a senior judge, a constitutional revolution. I realise there are others in the room who have a different view, and not simply some rule of construction. In the critical passage in his judgment, he said, some public comments on the decision of the Court of Justice, which I think was given just before the summer, wasn't it, affirming the jurisdiction of the courts of the member states to override national jurisdiction, if necessary, to enable interim relief to be granted and protection of rights under community law, have suggested that this was a novel and dangerous invasion by a community institution of the sovereignty of the United Kingdom Parliament. But such comments are based on a misconception. If the supremacy within the European community, he went on, of community law over the national law of member states was not always inherent in the EEC Treaty, it was certainly well established in the jurisprudence of the Court of Justice long before the United Kingdom joined the community. Thus, whatever limitation of its sovereignty Parliament accepted when it enacted the European Communities Act 1972 was entirely voluntary. Under the terms of that Act, it has always been clear that it was the duty of a United Kingdom court, when delivering final judgment, to override any rule of national law found to be in conflict with any directly enforceable rule of the community. The House of Lords debate, initiated by Lord Irvine shortly before the change of government in 1996, is significant not so much for understatement as it is for non-statement, for what was not said by those who participated in the debate. It's true that several law lords repeated the view, for instance, in the words of Lord Reid, that it was not beyond the power of Parliament to do things that were against strong moral, political and other reasons. If Parliament choose to do any of these, said that great judge, the court would not hold the Act of Parliament invalid. It was an historian in that debate, Lord Belloff, coming late in the proceedings, who emphasised the silence. Nothing he had proposed to say, he declared, had been said. All the previous people had said, everyone else ahead of them had said all of what they wanted to say virtually. The serious issue to which he was surprised, no noble and learned lord had referred, was the role of the two bodies of European law and of the two European courts. After all, he said, it is the cases which have involved the intervention of European courts that have been the most important in restricting the sovereignty of our Parliament. He was surprised that although many references had been made to Lord Denning, not much attention had been paid to the fact that early on he was one of the few senior members of the judiciary who pointed out that the whole British judicial and legal system would now be seriously altered in ways which had not perhaps been foreseen when the country acceded to the Treaty of Rome. And the historian concluded by saying, on an issue fundamental to our constitutional way of being, the law lords have on the whole been very reticent. The criticism, I think, has considerable force, although I think I would accept Lord Bridge from it. I'm not sure that Professor Wade agrees with me on that. But the criticism, as Professor Wade says, might also be directed at ministers in the long lead up through the 1960s into 1972 and the later referendum. That brings me to the third matter I said I'd refer to here, his 1996 contribution to the debate, a contribution which goes back to his path-breaking article of 1955. I'm persuaded by his conclusion in the more recent article that the judges, when faced with the novel situation presented by the entry of the UK into the European community in 1972, adopted or declared, even if it wasn't very explicit, a new rule of recognition or ultimate legal principle about the validity and effect of Acts of Parliament. Practical politics required that change on Britain's creation of the new ties with Europe. Perhaps the professor can speak with greater clarity and plainness than the judge or the politician. Certainly he did in this case, even if others in the Academy have been more cautious and have quibbled with his use of the word revolution. However the 1972 decisions are to be seen, it's undoubtedly the case that a major substantive limit on the area of the power of Parliament arises from the United Kingdom being in Britain. Another limit, to move to my third matter, arises from the dismantling of empire. Houston, to go back to his 1964 article, mentions the centrifugal forces at work after the adoption of the Statute of Westminster. I would have thought that they were at work rather earlier if you go back to 1776. He was inclined to think that a failure of the Imperial Parliament to recite the consent of a dominion when purporting to legislate for it would mean that the legislation was invalid. In that, he was adhering to the then new doctrine of parliamentary sovereignty, under which Parliament could rewrite the rules which define first its composition and second the procedure to be followed in making law, but it could not restrain its area of power as a sovereign legislature. But practical reality, international law, and much legislative and other practice, as well as some court decisions, show that the geographic area of the lawmaking power of the once imperial parliament has been drastically reduced. And that's to be seen not only here, it's also to be seen to a lesser degree in other parts of the Commonwealth. For instance, as territories for which New Zealand was responsible became independent or became states in free association with it. I might also mention that in 1986, in the Constitution Act I mentioned earlier, the New Zealand Parliament repealed, so far as they were part of the law of New Zealand, the remaining imperial constitutional statutes, including the 1852 Constitution Act, its amendments, and the statutes adopting the Statute of Westminster, and a little later a Statute Law Revision Act here removed the constitutional remnants from the law of the United Kingdom. I don't know if that quite makes us autochthonous, but certainly there was a considerable cleaning of the stables. I would like to go back for a moment to about the time of those young men on that famous tour to another aspect of the imperial legal and constitutional system, the top courts, a matter of debate, proposals and change, both in the United Kingdom and New Zealand at the moment. A century ago, there were, of course, as there still are, two top courts in the Empire or the Commonwealth, the Judicial Committee of the House of Lords and the Judicial Committee of the Privy Council for the rest of the Empire. At the end of the first decade of the 20th century, the Prime Ministers of Australia and New Zealand proposed that there should be a single imperial court, which would include Dominion judges, particularly when cases from that Dominion were being heard. There should also be provision for the publication of dissenting opinions, as happened in other appellate courts. There was support on that latter issue of separate dissenting opinions, although action was not actually taken for another 50-odd years at the urging of Australian judges who were refusing to sit, I think, in the Privy Council unless they had the time well-established Australian right to bicker and disagree, as we do too, I suppose. But the idea of a single imperial court received a polite rebuff, and it's remarkable looking back that efforts were made in the 1950s and 60s to revive it. Dominion judges did sit in the Privy Council in the early 20th century, but it appears that a New Zealand judge did not sit on a New Zealand case until the 1960s. And I think it's the case that the first New Zealand judge to sit on a New Zealand case and participate in the reversal of a Court of Appeal judgment was Sir Owen Woodhouse, to whom we were speaking on the phone last night, who sends his very best wishes to Sir David. So it's a rather recent time, that kind of participation. The power of the Imperial Parliament has always in practice then been limited in area and subject matter, and over time that became a matter of legal restraint. So too the power of the executive in Westminster became limited as colonies obtained responsible government and moved towards independence. And there was never a single imperial judiciary to enforce and apply imperial law in a consistent and uniform way. I leave you with the question whether those major limits on the powers exercisable in London over the Empire and Commonwealth were ever sufficiently recognised in the English writings, or in many of them, on parliamentary sovereignty. I come briefly to the fourth matter, touched on, fourth in that list, the question whether Parliament can redefine itself and require procedures if certain laws are to be enacted, require more difficult procedures. That so-called new doctrine of the 1950s and later says yes, but it has, of course, been strongly challenged. I mention the matter for two reasons, only to indicate the need for caution and the value of developing relevant conventions. On caution, consider a statute passed in the last days of a disputatious parliament by a narrow majority, which required that any later parliament had to have a 75% majority or a referendum of the people to repeal or amend any statute passed during that term. Such a requirement, the New Zealand House of Representatives has said, and this is no more than a standing order, but one you would hope with great force, can be introduced into New Zealand legislation only if it is adopted by the same majority. It couldn't be done by a simple majority in terms of the standing orders. On developing conventions, certain basic elements of the New Zealand electoral system since 1956 can be amended only with a 75% majority of Parliament or a referendum. That requirement has been consistently followed. Many would say there is a clear convention that it must be, and the Attorney-General, in the midst of a vigorous debate which led to the introduction of a proportional electoral system in New Zealand in 1993, declared that that requirement could be altered only by one of those special procedures. The fifth matter brings me back to private lawmaking through custom and more formal statements, and forward to the discussion of sovereignty in international law. As much writing about international commerce, finance, and communications makes plain, those critical parts of the world economy are governed in large measure by private law, formulated, to take just one example, by the standard terms of the International Chamber of Commerce. Over the centuries, some of those practices and standard terms have become part of the common law, for instance through the law merchant, have become part of legislation, as in some of the later 19th century commercial statutes. They've become part of treaties or model laws, such as those prepared by UNCITRAL, or restatements by learned societies such as UNIDROIT. Parliaments are, of course, free to legislate when a matter is governed only by custom, unless it has got to the stage of customary international law, or privately promulgated rules. But as the continuing existence of many of those rules show, that is frequently seen as not being the state's business. Better to leave the world diamond industry to sort out its own rules. Better to leave the IRB to sort out the rules of rugby, and so on and so on and so on. That reference I have just made to treaties brings me to the sixth matter, relevant to parliamentary sovereignty, the role of international law, and to my second major area of concern. That is, the place of sovereignty in international law and the impact of international law on national law. In this area too, facts are critical. T.H. Huxley once remarked, many a beautiful theory has been slain by ugly facts. Much recent writing has emphasised the growing integration of economies, of financial systems and information systems, and their impact on law and legal institutions and on the role of the state. It's a most interesting book by Jean-Marie Guéhenno, who was then the French ambassador to Europe 10 years ago. Now he's the Undersecretary General for Peacekeeping Affairs in New York, in the UN Secretariat. His book, in its French title, is called The End of Democracy. When it was translated into English, it became The End of the Nation State. But under both titles, it's a pretty dire book. The End of the Nation is one of the chapter headings, and another is The End of Politics, another is An Empire Without an Emperor, Imperial Violence, the Imperial Age, and so on. He said the nation now is too remote to manage the problems of our daily life. I think they're devolution. The nation nevertheless remains too constrained to confront the global problems that affect us. I think they're of Europe or larger international organisations. Whether it is a question of the traditional functions of sovereignty, like defence or justice, or of economic competencies, the nation appears increasingly like a straitjacket, poorly adapted to the growing integration of the world. He had earlier made the point that the state was poorly equipped these days to collect taxes because of the mobility of investment and talent, and hardly more effective in managing spending. He He continues by calling attention to the huge problems with defence policy, and then he turns to the legal system. No legal system, he says, can claim to be immune from international influences, and he mentions Europe. This constraint is not only the consequence of an institutional construction resulting from political will, it reflects the evolution of economies and the need to conform to international norms, which define themselves, he's here speaking of Europe, on a supranational level. A country that isolates itself within particular juridical norms, believing that it will protect its industry from incursions from abroad, does its industries a fatal blow, for it seals its cutting-edge industries within a market too restricted, and so on. Around the same time as that book came out, and these come out every year, the United Nations Development Programme and its valuable human development reports under a heading, The Shrinking World, give some of the facts and figures that support that heading of a shrinking world, and supports other expressions such as the global village or the world without borders. It mentions, for instance, the massive declines in the costs of transport and communications. The cost of maritime transport, it says, has dropped over the last 70 years to about a third of what it was. The cost of airlines per mile flown has dropped about the same in just 30 years. The cost of international telephone calls has dropped much more to about 1/50th, as I read the figures, since 1940. There's been an amazing increase, in part as a consequence, obviously, in the use of these technologies. Let me mention some New Zealand figures. Some of you may have heard these before, but I think they still make a point. The number of people flying in and out of New Zealand over the last 40 years has increased from about 50,000 a year to 4 million. The population of New Zealand is 4 million, and I should stress that that doesn't mean the place is completely emptied out. It's 2 million each way. But anyway, it went up from 50,000 to 4 million. In 1950, New Zealanders, in the course of the whole year, made 5,793 outward international telephone calls, or just under 16 a day. We know that because the Post Office counted each and every one and recorded it in the annual report. When that information was last publicly available about 15 years ago, before we had corporatisation and privatisation and so on, the daily figure had reached 100,000, up from 16. And that figure takes no account, of course, of faxes and later email. So there's been this massive change in some technologies, but we have to be careful about all of this because some things haven't changed that much. If we go back to the decade with which I began, and we go back to some figures from 1913, 17 industrial countries for which there is continuing data, taking those 17 countries, their exports as a share of GDP in 1913 were 12.9%. 80 years later, 14.5%, hardly increased at all. Capital transfers as a share of industrialised countries' GDP were still smaller than in the 1890s. And of course, way back at that time, there was a much greater freedom of movement of people around the globe. No real immigration controls in many places. So some things have remained the same. But the great technological and ideological changes, as 11 September in a way reminded us, we didn't need it to tell us, are not entirely benign in their effects. Some calculated well before then that the world illegal drug business, a transnational game, it's been said that's far more powerful than states themselves, generates revenues in excess of the total aid payment, the total public aid for development payment of $100 billion or thereabouts. In a recent book, a leading British and European diplomat, Robert Cooper, in arguing that interference in the internal affairs of another country is not an aberration in foreign policy, makes the point in these terms. The difficulty is that as borders become more open, itself a consequence of a foreign policy that has brought a long period of peace, the impact of the developments abroad increases. Foreign competition, the illegal trade in drugs, illegal immigration, and opportunities for international terrorism multiply. These challenges on the home front have their origin in problems abroad, wars in failed states captured by corrupt or criminal interests. All require foreign policy solutions. In war, foreigners arrive in violent and obvious ways. In peace, their arrival is less dramatic and their presence less obtrusive, but the effects can be just as far-reaching. The message of Robert Cooper, who is now a European official and until recently I think worked in the Foreign Office and then in the Prime Minister's office here, is called The Breaking of Nations, Order and Chaos in the 21st Century. And it's not clear to me in the end where he comes down on the order-chaos balance. Now, these developments for some decades now have led the international community to adopt a great raft of treaties designed to combat such evils. Just last Friday, for instance, in New York, the United Nations General Assembly adopted a convention against corruption. But that too is not completely new, that development. Again, going back a century, in 1899 and 1907, there were the first major international lawmaking conferences not connected, not designed to deal with the aftermath of a major war, the Hague Peace Conferences. It was a time of great optimism, and that optimism is reflected in the first inaugural lecture given at my university, at Victoria University College in Wellington, almost 100 years ago, by John Salmond. He didn't lecture on jurisprudence or on torts or on contracts, on which he also wrote an outstanding book, but rather international law he chose as his subject. And as I have suggested, he was optimistic about it. At about the same time as well, there were the first moves, thinking of human rights, towards the establishment of international labour law to add to the already extensive bodies of treaties governing and protecting trade, communications, intellectual property, and the victims of warfare, and providing for the meter as an international measure, and prohibiting the slave trade. There were thousands of treaties by then. Any country at the moment is bound by thousands of them as well. The orthodox view is, of course, and it was then, that Parliament here and in New Zealand can override those treaty obligations along with other obligations under international law, with the qualification in this country, however you see it, in respect of Europe. But the position under international law is, of course, flatly to the contrary. It prevails, and as declared in the Vienna Convention on the Law of Treaties, a party to a treaty may not invoke the provisions of its internal law as a justification for failing to enforce a treaty. Governments and parliaments, in our tradition, are very conscious of that overriding international obligation. So, too, perhaps increasingly, are courts, as I shall discuss right near the end. But before I consider the attitude of parliaments and courts and the roles of parliaments and courts, I should say a word about sovereignty in international law. Can we sensibly think of states being sovereign in relation to one another? Does not the standard meaning of the word incorporate within it supremacy of ruling over or from above? How does that fit with the idea that there are 191 or more states in the world community? There's a marvellous warning from 75 years ago by Professor J.L. Brierley, the Chichely Professor of International Law and Diplomacy at Oxford, that we must be careful to ensure that words are our servants and not our masters. This is not simply a matter of semantics, he reminded us. Since Hegel, he said, here he's writing in 1928, the belief in the state as a super-person has remained until our own time as practically unshaken, with disastrous effects not only on the clearness of our thought in political affairs, but also on action. He condemned political theory as generally treating the state, unlike the individual, as if it existed in a vacuum. And he reached very important conclusions, which I won't read to you in detail. His conclusion, if you come forward to 1945 to the Charter of the United Nations, is supported, I think, because the Charter does not use the word sovereignty in that absolute way. It does not include state sovereignty within its purposes and principles. Rather, its first principle is that the organisation is based on the principle of the sovereign, used as an adjective, the sovereign equality of all its members. And you have on the piece of paper in front of you, if you've got the piece of paper, an elaboration that was made 25 years on by the United Nations General Assembly in the Friendly Relations Declaration. All states enjoy sovereign equality, repeating in effect the provision of the Charter, and they have equal rights and duties and are equal members. So you start to wonder quite what sovereign is adding. In particular, sovereign equality includes the following elements. States are juridically equal. They enjoy the rights inherent in full sovereignty, but how does that fit with the other statements? They have the duty to respect the personality of other states. Their territorial integrity and political independence are inviolable. They have the right freely to choose and develop their political, social, economic and cultural systems, but they have the duty to comply with their obligations and to live in peace with other states. There's obviously a tension within that. What in the end can be the rights inherent in full sovereignty, given all those references to duties, to international obligations and to equality, spelled out, as I say, in thousands of treaties binding on the countries of the world. I leave those big questions, Briley said it pretty well all those years ago, and return to the role of national parliaments and courts. Again, we should give greater attention to the facts, in the first place to the legislative facts, than often happens. Over 20 years ago, a senior lecturer in law at Adelaide, now the Professor of International Law in this university, prepared an outstanding paper on the international law standard in the statutes of Australia and the United Kingdom, with passing reference to Canada and New Zealand. He provides a valuable indication of the extent of the impact of treaties on national law and the range of techniques used by legislatures to give effect to those treaties in national law. Each year, the British Yearbook of International Law provides additional material on the statutes enacted concerning matters of international law, as does the Australian Yearbook. New Zealand surveys of our statute book have concluded that of the 600 or so public statutes on our statute book, about 200, about a third in other words, appear to raise questions concerning New Zealand's international rights and obligations. If you take it alphabetically, it runs all the way from the abolition of the Death Penalty Act. New Zealand is a party to the protocol concerning that, all the way from that to the Weights and Measures Act. We finally signed up to the Convention on the Metre in the last decade or two. We need further studies along the lines of that done by James Crawford all those years ago. We also are in need of more scholarly studies of the steps that have been taken in a number of countries to exercise some control and influence over the executive's prerogative processes in treaty making. The relative absence of such studies probably matches the relative neglect of legislation generally in academic writing. Although, as I say that, I remember that in 1996, I think, due to David's persuasion, I actually stood here and spoke in a session on legislation, and most of the SPTL session of that year under Professor Tiley's chairmanship was about legislation, so maybe I'm slightly unfair to my academic colleagues. It seems to me, and I think I can say this now with somewhat greater authority than I could before, that cases and courts still get too much of the share of attention of the academic community. There's an awful lot of important things going on in legislatures and executives. I should nevertheless say something about the place of international law in national courts, first to emphasise the range of roles that it can and does play in national legal systems, second to indicate, again, a real practical restraint on national legislative absolutism, third to stress the value of thinking differently, and finally to emphasise the need for all parts of our profession to see things steadily and see them whole. I make the points very summarily. Much more can be and has been said about each. The first is, of course, that it is well established that while the making of a treaty is an executive act, the performance of its obligations, if they entail alteration of the existing domestic law, requires legislative action. The stipulations of a treaty duly ratified by the executive do not, by virtue of the treaty alone, have the force of law. But, and this goes to the other points I'm making, a treaty may have a national constitutional role. The Chicago Convention on International Civil Aviation recognises that states have sovereignty over their airspace. Those provisions, the New Zealand Court of Appeal has said, incorporate principles of customary international law which are reflected in fundamental constitutional arrangements and leave states parties free to exercise their authority recognised by international law. Next, treaties may be evidence of declaratory, or it may be evidence or they may be declaratory of customary international law, which is part of national law without any support of legislation. One recurring instance to be seen in judgments here and around the Commonwealth is the use by courts of the provisions of the Vienna Convention on the law of treaties. Treaties and proposals for treaties have been among the material drawn on as well in decisions about foreign state immunity and high seas freedoms. The next summary point is that treaties may be relevant to the determination of the common law, as happened in a major defamation case in New Zealand, the Longy case, but as did not happen recently in the House of Lords in the Wainwright case, the privacy case, where that kind of argument got fairly short shrift. Fifth, finally, my final point in relation to this, is that courts may interpret legislation, and this is the important area in practice, by reference to international law and treaties. Over a long time, in both our countries, the courts have stated the presumption or principle of statutory interpretation that so far as its wording allows, legislation should be read in a way which is consistent with the country's international obligations. Now, much will depend on the way the treaty is drafted and on the way the legislation is drafted. A great deal also depends on the attitudes, education and knowledge of the bar and the bench. Professional culture has great significance in this area. It may at times have greater significance than the technical aspects of the treaty or the statute. I just mention one relatively technical issue, which does have a wider practical and cultural significance, I think. Do you have to find that legislation is ambiguous before you look at the treaty? The answer to that question may be reflected in the very structure of the judgments interpreting the legislation. Not long ago, the House of Lords used to require, I'm not sure whether it really still does, a showing of ambiguity before it would go to the treaty that was relevant and perhaps was being implemented by the legislation in question. In New Zealand, on the other hand, the courts on the whole have not required an ambiguity. And you may see a difference, maybe going back to my initial story, you may see a difference in national as well as legal culture in that. It's very interesting, I think, to look at two sharply contrasting judgments given in the second half of 1982 relating to Western Samoa. One of them was given in the Privy Council, presided over by Lord Diplock. The other was given in the Western Samoan Court of Appeal, presided over by Sir Robin Cook. The Diplock Court, I might say, reversed the New Zealand Court, on which Sir Robin had sat in the New Zealand Court of Appeal. And if you compare those judgments, you do see the Samoan Court, consisting of 3 New Zealanders, beginning with the background, running through the history, and finally coming to the constitutional text. The Diplock Court, the Privy Council, on the other hand, begins with the statute and doesn't ever really escape it. And I think it's fair to say, and I have the great support of Professor Crawford in this, that they completely lost the plot, although I know there's at least one person in this room who holds strongly to the opposite view, maybe others as well. So those attitudes, those partly matters of technique, partly matters of national style, partly matters of education and attitude are critical. But I should end where I began, with that remarkable young group of New Zealanders who were left to figure things out for themselves. And I should, because I can't avoid it, come to the game near the end of the tour at Cardiff Arms Park, where at the end of the game the scoreboard read Wales 3, New Zealand 0. I have two reasons for mentioning that result. Again, the first is personal. Sir David probably would never talk to me again unless I did mention it. The second, more general reason relates back to my earlier discussion of ways of thinking and of space. I should put it into context by mentioning the test matches with Ireland and England that had occurred earlier. For reasons that I can explain later if you wish, it's enough that I mention Scotland in my discussion of parliamentary sovereignty. In the first, that is in the Irish game, the New Zealanders saw the paddock as an ever-changing pattern of lines. The Irish saw it as a kind of steeplechase, covered with low barriers and walls, which, so far as they were concerned, were there to smash into. They believed in luck. They were like children taking it in turn to kick a pebble down a bumpy road. The story of the English match was much the same. They had not thought of the blind side, where the New Zealanders quite quickly scored 4 identical tries. You would think they would learn, was the comment after the second. But back to the Welsh. They had learned. The New Zealanders had stopped being original. Wherever they looked, they saw a mirror image of themselves. The Welsh won. The lesson of all of this, beware of slogans. Think past the familiar words and formulas. Look for new spaces and new linkages. And ask yourself, to get back to my topic, is your reference to sovereignty, whether of Parliament or of the state, really necessary? Thank you.
We apparently have time for questions either on sport, including predictions as to what might happen tomorrow,
Last week was bad enough.
or on the very broad subject of the lecture. So are there any questions or comments?
Have the judges gone to any lengths in favour of making treaties and because we have very similar problem here, rights, and where the court has to interpret action Parliament if possible.
Yes, yes.
So it has to do with more. And in fact, they have taken a great deal far beyond ambiguities or similarities. No secretary claims that the judges have rewriting the acts of Parliament.
Yes,
Passes. I think one of the fact that's exactly what they're doing.
Yes, yes. Well, I quoted the passage from, I'm not sure which New Zealand case, which said that over a long period, the courts have stated the presumption or principle of statutory interpretation that so far as its wording allows, legislation should be read in a way which is consistent with the country's international obligations. And that's something that's actually taken originally from a judgment of Sir Robert Fillimore in the Kane case, the Franconia case, which is 1870s. And that's been said in maritime cases. I wrote one judgment once in which I took it back beyond them to John Marshall in the United States Supreme Court. So courts for at least a couple of centuries in our tradition have been saying, quite apart from a statutory direction like the human rights one, that we should, so far as we can, keep our law true to international obligations. And as I indicated, that's also been the case in looking at the common law, thinking of the law of defamation. So I think one very large change that's happened, and it's the kind of thing, if I didn't have this current job, I'd really be very pleased, I think, to get back and be an academic and read this material and think more about it. I think there's been a huge change in the last 50 years in the sources of law. People now look at a much wider array of material. It's partly the fault of the Xerox machine, I think, but it's partly a matter of a different mindset. It's partly a matter of authority being seen differently, I think. The very top-down view that I had when I was a student, that Parliament was way up there, and there were these people called the judges way up there, very lofty people, and they just handed the stuff down. And they were the only sources that were referred to back then. That seems to me to have gone to a very large degree. And after all, it wasn't true more than a century ago. People did look at a wider range of sources. And so part of the answer, we haven't been definite about it, I don't think, but I think it's a matter of judicial technique. And if I think of, again, of the Cook-Diplock distinction, I should actually come clean. I was a member of the Cook Court sitting in Apia in that case. So I can say I've been a judge for 20 years. I mean, most of the time I haven't been, but in that case, you do get a very sharp difference between those two judgments as a matter of structure. The Samoan court says we've got to look at all this background, including the United Nations material, including the debates about universal suffrage, which was the issue, and so on. We've got to look at all of that. We've got to take all of that into account, and then and in that we look at the text. And the Diplock Court didn't. It began with the text, and there was a very important resolution of the League of Nations relevant to the issue that they were considering, which they say at the end, well, the government's got a good point here, but the League of Nations didn't know what it was doing. The Council of the League of Nations didn't know what it was doing in talking about citizenship in mandated territories. Well, I know Lord Diplock was a great man, but that's a rather breathtaking statement to make, I think. So I think it is partly the long history. I think we do take a wider view, but we haven't. It's partly the conversation we were having before, Bill. I think that it's harder for me as a judge actually to be as articulate about these things in a judgment as I can. I used to try to be in an article. So I think we need more attention to those matters of technique. I think from the scholarly community. So it's not a clear answer, but there has been a huge shift, I think, in method, and it's a shift I think that in some ways goes back in terms of method to much earlier times, when someone like Mansfield would use a great array of material and try to work out what bits of maritime or mercantile law were. This statement.
Has the unique camera rules been a success?
New Zealand got rid of its Legislative Council, its upper chamber, which was an appointed upper chamber in 1950. A provision had been made in 1914 for proportional elections in that parliament, but because of the First World War, that legislation was suspended. And I think it's the longest lasting statute on the New Zealand statute book that never came into force, all the way from 1914 to 1950. By 1950, it was thought that the upper house was hopeless, wasn't achieving anything, and didn't serve any kind of revising process and so on. What has happened in New Zealand, I think it's fair to say, is that our select committee process has become much more significant. It goes back at least 30 years. It started to happen a bit in the late 60s, but certainly from 1972 on, from the Kirk Labor government on, select committees have become much stronger. Nearly all bills now go to select committees. They're open to submission by members of the public and by organised outfits. The person sitting to your left, on behalf of the National Council of Women, made hundreds of submissions to select committees, and they do have a real impact. And increasingly now, of course, when governments, usually minority or coalition governments, or coalition minority governments, they have to take account. But even in the days of very big majorities, select committees have had a huge impact. Jeff Palmer, for instance, wanted to get a new crimes bill when that government had a massive majority, and that bill didn't ever get reported out because of the criticism of it in the select committee. So I think that we've had some of the advantages of second chambers, the revising sort of advantage through the select committees, and now I guess through having proportional representation, we don't have quite the same worry that used to be of the Parliament rushing ahead and legislating overnight to do things. I mean, it's not the case anyway, as if the second chambers necessarily stop that. I've sometimes been impressed when I've been interested in legislation being passed in New Zealand and Australia, but the Australians sometimes get it passed more quickly than we do, because the Senate will sometimes fall into line. Not always, and the Howard government's having trouble with the Senate at the moment, but the Senate doesn't always have a revising function. So I think our select committees have provided part of the answer on that issue. Yes, yes. 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 Sure.
Does this represent legal, it certainly doesn't represent political reality, does it represent legal reality, or is sovereignty, no, really, whatever, exercise of autonomy, a state can get away with it?
Well, autonomy, I think, is a better word than sovereignty. And you see something of that idea in E, don't you? This text was one that began getting developed in the early 1960s, and it was adopted unanimously by the General Assembly, and it came through the Sixth Committee, through the Legal Committee, and it came through the Friendly Relations Committee. The Friendly Relations Committee had its last meeting in Geneva, I should say, on about the 28th of April 1970, just before I came over here and met David for the first time. And so there was this very long, difficult negotiation trying to produce these texts. But I think the things that you can get out of it that are significant are going back to Briley's article, and it's better to look at the product of one mind, as with Briley, than the product of this committee plus the rest of the General Assembly. You do get the notion of limits and restraints and so on. In terms of practical politics, I mean, within the UN context and legal reality, you've got to take account of the veto, obviously. In terms of practicality, you've got to take account of the power of the United States particularly, and back then the power of the Soviet Union and to some extent of China, which hadn't yet come in to the UN as well. But I mean, it's an example of an attempt to get a political legal text. But the reason I included it was to make the point that that paragraph B doesn't actually hold up when you read it with the rest. Rights inherent in full sovereignty, when you've got duties and you're equal and so on. But yeah, there's a much wider issue that arises out of your question. There's a recent book by Paul Krugman of his articles in the New York Times called The Great Unravelling, and that's about the very serious issue whether at the moment the United States is not engaged in that. But that's for another occasion. Does anyone know what Lord Steyn is going to talk about in his FA Man lecture? It sort of looks a bit like that sort of topic that he's discussing. But that would take us off into a much different direction, I think.
Well, Sir Kenneth, speaking first of all as an international lawyer, it's great to have the Centre for Public Law hosting a lecture, at least half of which was recognising the international law. But of course, speaking as chairman of the faculty, the various centres we have are part of an integrated faculty in which people range across areas of law as their interests and their scholarship require. That's absolutely right. To departmentalise a law school would, I think, be a fundamental conceptual error, quite apart from being organisationally chaotic. And so we certainly don't do it here. The only times that I've known it, whenever you had a departmentalisation of a law school, it was because two dead professors hated each other.
Yes.
But of course, the non-segmentation of areas of interest is absolutely characteristic of Sir Kenneth himself. He's had the most extraordinary career as a law teacher in a whole range of areas, as a legal educator in the broader sense, as a member of the president of the New Zealand Law Commission, which did a great deal of innovative work, including some in international law. One of the publications is widely cited as an international law text coming from New Zealand. Also had an influence even in Australia, I might say. And then, of course, his influence on some of the Pacific courts and on the New Zealand Court of Appeal and even on the Privy Council, albeit that this may be subject now to a fairly decisive sunset clause. But that breadth is something we need if we're to avoid the great unravelling coming from one direction. We will see whether the unravelling happens, but if it doesn't happen, it's because of our capacity to think across categories, across disciplinary borders in the way that you've shown tonight and throughout your career. We wish you well in your judicial career, national and we hope international.